Guess we can get started now. So I want to thank everybody for attending this evening to our discussion on wills and estates. We are very happy to have Lilián Cazacu join us today for this discussion. Just before we get started, feel free to ask questions in the chat box. Lilián, did you want to, I can't remember, did you want to wait till the end, or can I stop you throughout the presentation and ask questions?
We can do both. If there are questions that are very applicable to what I'm talking about, you can just put your hand up or just let me know that you have a question and we can stop and just dig deeper. But we'll have a space, a time at the end to deal with the questions after the presentation as well.
Okay, that's great. So yeah, so feel free to type any questions in and we'll do our best to answer all your questions. So just before I hand it over to Lilián, I just wanted to give you a little bit of update about the foundation. We're hosting this event tonight in conjunction with Lilián. And so for the foundation, it's been a pretty eventful year. We opened our new emergency room and MRI. The emergency opened in May. It was a $17 million campaign, and we're really happy that our community helped us raise the money, and we've had excellent feedback on how it's improved patient care at the hospital. So we're pleased to have been a part of that. Now we're on to a new campaign. We are now in a $2.1 million campaign to bring Foundry Langley to the area. So Foundry is a program to help youth with mental health issues. So it's a huge space that we're renovating and we're helping build. So we can provide the best mental health facility and programs for Langley youth. It's estimated to help about 1,000 young people a year. So we're very proud to be a part of that and to raise money for that really important project. And lastly, as now that a lot of restrictions have eased off, we are back to our in-person events. So in February, we're having our Giving Hearts Gala. That is the 12th of February at Glass House Winery. And then in May, we're going to have our annual gala as well. We don't have the date quite yet for that, but in the chat box, I have put our link to our news. So if you have any questions about the foundation and what we're doing, just feel free to click on that and you can get all the information about what's new and with us. Anyway, so I'll turn it over to Lilián. We've got a lot of information to discuss, so I'll let him take the lead on this conversation now. Thank you.
Thank you, Lisa. So welcome everyone. I have few screens in front of me, but I can't see your faces. So if you have a question, just raise your hand or send a message on the chat. As I said, I'm happy to dig deeper if you need to, but we have some slides to go through, at least to make you leave this presentation with some understanding what is estate planning, how that works, and why there are some documents that are needed to be prepared, and just I know that you'll have some more questions when you leave this meeting tonight, but I really think that you'll have at least the big picture in mind. At least you can talk to your family and you can have a better understanding of this. So this being said, so we'll start with the just to let you know who I am. In my 20s, after I got married, I was born in Republic of Moldova in Eastern Europe. And, after you have a baby, you realize that, in a country like Moldova, I don't know if you have friends there or, you know what the situation is, but it's really hard to support a family, especially when you have a baby. So we started looking outside of Moldova and trying to, although I was a lawyer with a master's PhD, but we just couldn't afford to live on a salary as a lawyer in there. So we started looking out. I immigrated here in about 2005. So then because I couldn't speak any English, so I had to go back and start doing my redoing my education, got another master's degree at SFU, became a notary public in 2014. So for about 8 years now, where I'm here in Langley, serving the community here in Langley, with office in Langley by Costco and another office in Aldergrove by appointment only. So we have a little office there as well. So in my career, I worked as a lawyer. Then when I came to Canada, I worked as a paralegal, drafting wills and stuff. And now for about 8 years, I'm here in Langley as a notary public. So I've done all this cycle of legal profession, and you know, if you have questions about any of the areas, I kind of grew up into like a all-rounded professional that I can, yes, as a notary, I cannot practice family law and other stuff, but we do Wilson estates, we do real estate mortgages, as you can see, and in the last few years, we've been you know, awarded me personally and as a corporation as the business person of the year at the chamber event, the entrepreneur of the year, and the BC immigrant entrepreneur. So I guess I'm doing something right since I started the business, and you know, but my passion is to promote financial and legal literacy in our community, because I think in school they have to teach more of that. I have a lot of clients who learn about credit cards late in life, and they learn the hard way how the credit card works and how an estate plan works. So I think it's good to, we're pushing on getting at least high school to learn about these things as well. So this being said, so we'll start with the last will and testament. So, and I'll kind of go through some facts and some tips that we can give you, at least for you to understand. The estate planning, when people talk about the estate plan, it's not just the will. So I know that everybody is like, oh, you need to do your will, you need to do your will. But it's not just the will. If you have a lawyer or notary that just you approach and they just, oh, let's do a will and really quick and half-an-hour meeting and, you know, come back in a week and it's done. You know, you have to be careful of that, because, you know, you don't get the same product or the same service from everyone who you approach. There are different types of notaries, different types of lawyers with various experience. So check the reviews, check the experience, the background, to make sure that you have the proper estate plan in place. So the last will and testament is just a document that sets out just the main information. It's who is the executor, who. So by the way, an executor is the person who you allow to manage your estate, and when you're not alive anymore, you appoint a guardian of your minor children if you have minor children, and also the talks about the distribution of the estate, your funeral wishes, cremation, burial, and stuff like that, right? I see here a fact that we put here for you. You know, about 50, in this case, 56% do not have a will. And there is a funny statistic, maybe not funny, but half of those who have a will, they don't have it updated. So you can say that maybe 25% only of the population have a good plan in place. So main excuses that I hear from our clients is, oh, I don't want to talk about that. You know, it's just not pleasant. I have people who actually got it too emotional, and I know that it's not a pleasant topic to talk about, but it's, if you care about your family, and you can see that this topic that I chose to, it's a family matters, because I'm a family man. I have 4 kids of my own, so I do understand how that works. Maybe they're not at that age that I can see their families and their grandkids and all that stuff, but you know, and you guys could be on different stages in life as well. So I don't know what is happening in your lives, but for sure, you know, there's no such thing as a regular family anymore. There's so many blended families. There's people with kids from various marriages. That estate plan is even double or triple complicated. So if you know somebody who have a second marriage or kids from previous marriages, make sure you have an estate plan, because the regular plan that normally people do, like everything goes to the spouse and then to the kids, could be a disaster for a blended family. So just watch for that. Other people just, you know, oh, you know, they say it's like only the rich people need a will. I don't own so much, so I don't need a will. Or, you know, they ask me, it's like, on the law or the government provide a way of, you know, to divide the estate? Well, the answer is yes, they will. I'm not sure if that's what you want, but, you know, for sure there's some rules of, you know, if you die with a will, it goes through probate procedure. If you die without a will, or a will without an executor, it goes to administration. So there's a public guardian and trustee, an agency, a provincial agency that just will appoint somebody. So where the family will apply and if approved, they'll become an administrator. And the last one, it's not the last one, but it's most people think they're too young for, and with COVID and all the other things happening in the world right now, it's never too soon. It's good to have a power of attorney. It's good to have a will as soon as you have a property and as soon as you have a family. So that's my approach to it, and you'll see from the next slides why is that. So I put together just some of the tips, or in this case, just top 10 tips for a sound estate plan. So if you want an estate plan, just if you try to write them down or try to kind of make your notes about these 10, obviously you'll have more questions, but at least you would have the good picture of this. So first one, try to not leave it to when you're 99 or 89. Try to look at your family, look at what needs you have, how many kids you have, if you have a second marriage, if you have assets, or you have a disabled child, or if you have, like, I'm saying this when people ask me, why can't I just go online and buy, a kit, or, just there's so many lawyers right now that they contacted from Ontario and they say, we have lawyers here, just give us the information, we'll just draft the will, well done. So I say that this is kind of like buying shoes online without knowing your size, right? So it's like, okay, so it's looking good, like shiny, just click, bought, and you don't know. And obviously you will never know if it worked or not. That's not the funny thing, but it's the dilemma, because it's the family your family will have to deal with that. So my advice is if you want a custom-made estate plan, so make sure the notary or lawyer looks at your estate, looks at your family tree, looks where you are, where you stand, what's the specific part of your estate, and and there's not a thing that it's too early to look at that. So that's number one. Second, seek guidance. I said that already. Find a qualified legal advisor, a notary or a lawyer. So mostly a good question would be, like people ask me, what's the difference between a notary or lawyer? So we notaries, we can do simple wills. And we normally suggest having a simple will, even if you have a more expanded or complex estate, even if you need to prepare a trust and other complicated stuff. But for a simple will, a notary is good enough to make. Again, look for a good, experienced one, but a notary public can be qualified to make 95% of the wills. And like, again, I don't want to generalize, but most people can be having a will done by a notary. If you have a more expanded estate and you have family trusts and all that stuff, that maybe a lawyer will be more suitable for your situation. Okay, but make sure you have a professional, okay, helping you with that. Again, the cheapest one, if have nothing, or do it online. The most expensive is having a lawyer, expensive lawyer in downtown Vancouver or like Surrey, that there are big companies that they charge $2,000 or $2,500 per will. And again, like, I don't want to say how much I'm charging, but it's like maybe 10 or 5 times less than that. Keep in mind that many other decisions, like buying real estate or how adding somebody on title or something, that's part of your estate plan. So some people think that making a will is, like, oh, I'm not doing an estate plan because I had a will already done 10 years ago. Yeah, but you bought a house in between. You added your daughter on title in between. You separated or something happened. So all this stuff affects your estate plan. And I'm like, maybe almost every meeting that I have with my clients this is the question that I ask: how do you own your house? Because the house is the biggest asset that you have. If you have it registered as joint tenants or tenants in common, that's the common question that they have. What's that? And if you have, I can maybe go into that a little bit later in the presentation, but asking yourself, how do I own your house? If I die, sell, or separate, does it go how I want to go? Because the house obviously is the biggest asset, right? So if you have most people, that's the 90% of their assets, right? So watch for that. Make sure that if you have any changes, if you want to remove somebody from title, or you refinance your house and the bank wants you to add your mom, dad, or daughter or son, talk to us. Talk to us to make sure that this is a good plan, because the bank doesn't care about your estate plan. They just give you instructions how is the best for them to put, you don't qualify for a mortgage. Maybe they want your brother, sister, mom, dad to get on title. But is that how that is affecting your plan? Most likely is creating issues, tax implications, and other problems, right? 4, choose an executor or trustee wisely. So choose somebody who is available, who wants to do it, who is local, and who is trustworthy, who is, you trust that they'll do a good job. And that's important. Sometimes we notaries, lawyers, banks, we are it's good to have a professional in line. So in case your family says that, oh, I thought I'll do it, but, and I hear that a lot. When it's time to do it, it's like, oh, I didn't think it's so much work, and I just don't have time. So would you do it? And normally we can't at that time. So we have to think wisely more in advance. 5, if you have minor children, you must have a will, right? So you have, like, if you do care about your kids, okay, let's back up. So if you don't care about your kids, if that's you, well, maybe you don't need a will, it's okay. But if you are the majority of people who care about their kids, choose a good guardian. So think about, not necessarily to be your family member, because I have a lot of people, immigrants, that they don't have family here, or maybe they're born here, but they're not in good relationship with the family. Could be friends. Just think about who are the best people who can take care of your kids, right? So it's a must. 6, if you have any personal effects with sentimental value, so you have like a painting or like, some stuff that you really care about, either take care, like it depends what age you are, most likely maybe we don't have people that are retired in the presentation, but if we do, then start starting distributing those assets before the death. First, nobody will fight for them, I have sometimes people put like a sticker up under the vase or under all the stuff, and the grandkids jumping and playing in the house and looking, oh, that's mine. Oh, that's my mom. So there are various options, but just again, a professional obviously will help you how to do that. But sometimes either get rid of those before that, or make a letter of wishes that says exactly where those go. Which kid gets what. I see a question here where my will dates back to 1970s. Is it still valid, or do I have to make a new one? Also, if I don't need a new will, am I able to add to it? Okay, so I'll answer the first question. There are 2 questions here. Yes, it may be valid. So I cannot say if it's not valid or not. We at our company, we have a policy right now. We give a review of the will, because it takes me 5 minutes to look over it and just give you a call and just say, okay, everything looks good. Maybe you need to change this or that, but otherwise it's good, valid. But you have to take into consideration that the legislation from the 60s or 70s have been replaced in 2014. So there are some big changes in there. But again, if it's done properly and you read it through and everything that you read seems to be still valid, still the same people getting those. If it's from the 70s, most likely the executor is too old, or maybe you need I normally say choose an executor that's younger than you, or choose a company that will stay alive a little bit longer than a person, right? So, but yeah, so if, again, like if you want to send me a copy of it, and I'd be gladly look over it and just give you peace of mind that it's good, don't have to touch it, or that you have to make some changes. Now, the second question, if you want to make some changes, so there are 2 ways of dealing with those. Either you make a codicil, which is like, I call them a tail. So you add a tail to the will. So because it's just an amendment, the will is still valid, but the codicil will say, paragraph 5 of this will is being exchange of this. First of all, most of the times the codicil are made by a different lawyer or notary, and then a lot of litigation issues with that. So how about if the will maker, or I should say the lawyer or notary who prepared it, is not around anymore? Whose insurance, if something goes on, gets triggered, right? So that's one question. Second, that mostly codicils, like, again, I'll give you, maybe I didn't want to say at the beginning, but like for codicil, we charge about $295 or $300 or something like that. For a will, it's if you do it together, a power of attorney is just $395. So at this time, So if you contact me in a year from now, I can't promise. But if you do it separately, it's just $495. It's a little bit more expensive if you do just the will. But if you do it together, power of attorney, it's not much more expensive. And I say, how about you just make a new will? It's all done. Thank you, Lisa. Yeah, that's my website. But the idea is this: if you want to be, it's more about peace of mind as well. It's not just about saving taxes, doing this, but just for you to sleep well at night and say, hey, I've done all the package, I put it there, it's on the shelf. If something happens, I trusted my notary or my lawyer did the right job. Yes, about 3 to 5 years, look at it to make sure nothing changed, but you should be okay. I hope that answered. If not, please feel free to send me an email. Maybe, is it okay? I just put here my email address as well, just in case. So feel free to email me after that as well. Okay. Where were we? 7 or 6? 7, right? Consider creating a funeral plan. Yeah, that's a good idea. I have more and more people do that, especially I think older people. Honestly, I don't see people in their 30s thinking about that. If they do their wills, which actually it happens a lot. I have a lot of young people in their 30s that which is weird. I have people in their 30s and I have people over 65. But people in their 50s and 60s kind of are too comfortable. I think I don't know what's happening there. So, by the way, if that's you, do your will, okay? But yeah, it's a good idea because then you make a funeral plan, you put it aside. Some funeral companies actually order your death certificate. They allow you. They basically guide your family through the first steps, which can be very confusing, can be very upsetting, and especially taking consideration all the grief that family goes through. So it's stressful for sure. We register, number 8, we register your will with vital statistics normally, and we suggest doing that. It's not mandatory. And by the way, you don't send a copy to the government. So when I say government, I mean vital statistics in Victoria. There is a registry, not for a power of attorney, not for representation agreement, just for the wills. And the only thing that we send them is a notification about the person's name, date of birth, place of birth, and where the will is located. So don't worry about sharing too much with the government. They don't care about the other details in your will. They just want to know if you had the last will and where it's located. So, and that's the first thing to do when a person dies. They have to do a will search to find out what's the last will. I'll make a parenthesis here. Even if you have a will registered, don't think that that's solved. If you lose your originals, you're still in trouble. So make sure it's saved like we normally save copies in our files. We send a copy to the client to save on their computers, but the originals, in the past, lawyer kept the originals, and we have a lot of problems with those. Either the lawyer died or retired. I had one lawyer that did a renovation, put all the wills on the stairs, and the janitor threw them in the garbage. So lately, I see a lot of people just want to keep it at home or at the bank. Okay, can you write your own will and get it notarized? I'll divide this question in half. So there are 2 parts here. Can you write your own will? Yes, you can. Go get a course or read something. You know how to do it. You feel comfortable doing, no problem. Do your will. Make sure you properly sign it, properly witness it, no problem. However, I don't think you'll find a notary who will sign it, because if you come to me, I'll say, I can't, first of all, I can't put my insurance in place if I haven't prepared the document. And our insurance has a problem with us notarizing a will. So think about this. If you come to us and just notarize a document like a statutory declaration or an insurance paper from ICBC or something, those are simple because those are just declarations. So you come, you sign, I check your ID. That's what a notarization is called. But if you need an agreement or a contract or a separation agreement, let's say, we don't do those. But if you need those or a will, those require legal advice. If I put my stamp or my signature on those, that implies that I gave you legal advice. And if it's not done properly, it's kind of how you'd get me something from dollar store, and I'll put a brand on it, like it's like, you know, this is Lululemon, or this is, you know, whatever, you know, something brand name, right? So again, maybe there's a notary out there that doesn't have any work and they would want to make some money, and maybe they'll accept to do it, but most people will not be doing that, you know, and you can just notarize it. Is it? Yeah, is it? It is legally binding. So let's say I'm a retired paralegal. I know exactly how to make a will. You know, I'm confident. And I go and draft my will and just, you know, make sure that the 5 elements of a validity of the will are check. So you have to know those. Read the WESA, the Wills and Estates Succession Act. And if you do it properly, witness it properly, yes, it is binding. So according to British Columbia law, and by the way, every province is different. You have friends or family who moved from Saskatchewan or other province, make sure they check their will. You know, it might be valid, but might not. For example, in Quebec, they allow, how they're called, a holographic will, right? So sometimes they just, you know, and WESA, the new law, kind of relaxed the law a little bit. So sometimes, you know, I have crazy stories about what was accepted as a valid will. And sometimes, maybe you remember the Pat Quinn, is that the former coach and the goalie for the Canucks? So there's a big case law in the Supreme Court, and because he had a U.S. will that wasn't accepted in BC. So the whole, and he had a big estate, that was a big litigation there. So I know you may say that you might not have the money that Pat Quinn had, but you'll be amazed how many people fight for just little money. Just sometimes it's just amazing. Okay, so back to our list. Number 9, consider including a charitable gift. So that's basically, think about this. If you have a church or have a like Langley Memorial or any other charity that you care about, and you give them during life, let's say 10% or whatever, you know, in putting aside for charity, just think about that in your will as well, you know, because at the end of the day, first of all, you get a charitable credit for, you know, it's basically a tax credit from CRA. And you basically, if you put them together, you get at the same amount. So if you get that credit and the taxes are minimized, you help your local charity, plus your kids are still getting some anyways, right? So, or whoever you give the money to. And 10, review your will regularly. As I said, you know, it's not only good to have a will from the 70s or whenever you made it. It might be good, but it just, the Goldilocks zone is about 3-5 years. You won the lottery, or you lost some people in your life, or you maybe don't have the trust in those people who you appointed. It's good to have a look at it. If not, just send a copy to us. We'll look at it. We'll have a chat, and we can say it's good to go or not. Susanna, do you need to create separate wills for me, my spouse, and another one to cover conjugal properties? Yes. So a will is not an agreement. So it's not a contract. So a will is per person. I know that they say when you get married you become one and stuff like that, but no, you don't make a will together. You have to have a separate will for separate people. Now I don't know what you mean by conjugal properties. I'm assuming this is a house that you own together. Is that correct? If that's correct, you have to look on your title search if you own it, joint tenants or tenants in common. Again, I'm not sure. I think I have a slide about that particularly, but you know, I can open up a little bit. So joint tenants means that, so look on your title. This is a homework for you. Everybody, if you find the title search, which means your last notary lawyer when you bought your house, when you refinanced, you have a title search at home. If not, ask your notary to send you one, a state of title certificate or title search. Look on the first page, you'll see your names, and under your names, you see 3 magic words: as joint tenants. If it says as joint tenants, it means that if one dies, goes to the other 2 or 3 people, or just to the other one. If it doesn't have that word, it's tenants in common. That means that you still own it proportionally. If you're 3 people, you're a third each. If you're half, it's 50-50. Or it could be 90-10 or 99-1. So if that's the case, then that particular property would not go to the survivors, but it will go to your will if you have one. Okay. If not, then you know, again, talk to us or talk to somebody who you trust that can look into that and give you proper advice, so you're not having insomnia at night. Okay. I hope that answered your question, Susanna. Okay. So what happens if you don't have a will? So that's a question that I normally get. So we call it intestate. Why intestate? Because the government has some rules, intestate rules, meaning that there is a formula where it's going, who gets, you know, the spouse gets some, then the kids get some, and we have many situations. We have just a recent situation that they didn't mean that way, but actually the niece, who, like, the closest next of kin was a niece, and she never talked to them. They never saw it in their life. So $500,000 will just go to a niece that was found in Germany. So here you go. So what the intestate mean? It means that you can choose who the beneficiary will be. You can choose who will be the executor or administrator. You can't even plan your estate or minimize your taxes, because we normally say there are 3 advantages that we, particular our office, try to accomplish. Make sure we save you taxes. Well, at least do an estate that minimize tax payable, you know, probate and other ones. Minimize the issues or the litigations or the problems with the family members, and minimize fees in the long time, because if you do it one time well, then you don't have to pay here and there to fix your estate or to fix your title search or your title, I mean, right? So these 3 is kind of like some of the top goals that we have. Not just making a will and, you know, okay, done, next, right? So that's nice, you know, and I know offices that do that really quick ones. You know, I have few clients that say, oh, you know, you're first person who actually talked to me about almost an hour until we talked about the actual stuff, because we look at the family, we look at the financial part. Some people don't like that because it's like, oh, it seems like I'm like still naked financially. Like, you can see everything that I have, where I spend my money. So by the way, we don't need all of the details. We just need the basic where this stuff is, so we can advise you, hey, this amount is taxable, this is not taxable, this goes through the will, this doesn't, this goes straight to the beneficiary. So by knowing those things, I'm not a financial planner, I can't give you that advice, but I can say, okay, in your case, maybe we need to look at that and reshuffle the things a little bit, right? So all these disadvantages of obviously dying without a will, it's not a good idea for a family. I have a real case scenario here. A family member was dying without a will, and I think, well, actually, that was the story of the niece. I thought I didn't put it here, but that's the one. I had another one recently about other stuff that, you know, people leave it until the last minute. They weren't in good relation with their kids. They made a will, well, give instruction in April, let's say, and then until October, we couldn't get a hold of them. So now one of them has dementia, the other one is dying of cancer. They're locked down in the hospital. So what can we do, right? So don't leave it to the last minute. That's kind of the story. I have a funny one here. Here the attorney is saying, you know, I think that's the shark telling to the fish. I know that's why they call attorneys, I guess. I know it's difficult to discuss these things, but you should state your wishes. Now, do you want to be packed in water or oil, right? So I know it's sometimes we notary lawyers have a little bit of a black humor, but you know, you can't, otherwise you can't really talk about this stuff because it can become really depressing. You know, people look at that and just forget about talking about that. It's just, they push it in the corner. Nobody thinks about that stuff because nobody likes to think about that stuff. But I strongly suggest everybody to at least start talking with your family, and that's a good start at least. So we said that the estate plan is the process of anticipating and then arranging all these documents and planning, and maybe have a binder. I don't know, maybe I have it here with me. There's a company that gave us a few of these, so Basically, it's a binder that has tabs for personal information, financial information, investments, insurance, medical, real estate, vehicles, power of attorney, and then if you have any other original documents, maybe you can keep it like that. So they're selling. So they said, can we give 10 in your office? So we keep them here. Most clients just get at least the idea and create their own, or you can go to Staples or buy something like that you can have everything in one place. And again, either you put them at the bank or keep them at home. It's still a good idea to keep it all in one place and make sure your kids or your family knows where it is. Okay. So estate plan can mean, we said about that, maximize the value of the estate by reducing taxes. Your estate, when you say estate, means everything. So people ask me, well, how about RRSP? Well, if you can look on the bottom of my slide, I kind of mentioned some of the assets. So that's life insurance, RRSP, TFSA, I call them register accounts. So those ones can go straight to the beneficiary. So this one avoids probate, and it's confidential. So if you have a kid that you want to give more, then some people do that through RRSP because nobody, or TFSA, nobody can find out in a way. The will, by the way, it's challengeable, if I can say that. So it can be challenged mostly by two categories of people. We in the past it was there was an act called Will Variation Act. Now it's all in that WESA, Wilson Estate Succession Act. But spouses and kids are ones that are covered here. So even if your kids are adult and you want to kick them out or give them less, it's a little bit hard. So you need a professional to make sure you plan it properly and make sure you don't have them paying lots of money to lawyers to settle the estate later on. Okay, so warning about that too. So I put a good estate plan in 5 components. So again, like I gave you 10 tips, and now I'm giving you 5, like I could say 5 puzzles, right? So a good estate should accomplish this. Avoid your probate fees or minimize it as much as you can. Actually, I say one thing and people laugh at that, but the best estate plan, listen carefully, is when your last check is going to the funeral home and it bounces. Okay, so that's the best plan. That means you plan it properly. So when everything is done, most stuff was already distributed, or it's according to RRSP or TFSA or the house and joint tenants. So you minimize that probate fee or minimize that probate procedure. So if you are a spouse that have bank accounts, RRSP, TFSA, both names, and the house and joint names, most likely probate is not even needed at the first death. So that's, again, at the second death is a different story. You may do that too, minimize probate, but it's a little bit harder. Okay, then save taxes. 3, protect assets, because you can put them in you can name where they are going, or RRSP especially, or TFSA, they have a beneficiary designated where it's going. And also it make sure if you have a disabled person or something, make sure you have like some requirements for them and how that is being taken care of. And again, that's a big one. The last one, protect against family disputes. I know your family is special and they'll never do that, but believe me, I've experienced, actually I have a saying, the people who are now in court, sorry, you want more slide? People who are now in court fighting with each other, at some point they're family or friends. So because, otherwise, you have to come in some good close contact before you start going to court and start dividing things. Okay. So now, what are the documents that are? So we said about the will. So the will covers all how you to divide the estate and who covers your minor children, how to do the funeral wishes and stuff like that. So that's the will. Now, people ask me about trust, and people think that if you have a trust, it's a sexy, nice name. You cover, and accountants like to talk about that because you can save taxes and stuff. But think about the trust as a corporation or as an entity. So, unless your estate is $2-3 million and up, sometimes maybe it's not a good idea to have a trust. It's expensive. You're basically buying yourself a pickup truck if you're just going back to the store and back, right? So it's a big machine that you don't need it unless it's really necessary. If you have a disabled person, or you have people that are drug addicts, or that it's hard to give the whole estate to them because you want to kind of take care of them, but still like don't give the hundreds of thousands cash in their hands. Or if the kids are too young and you don't want them at 19 to get those hundreds of thousands of dollars, right? So the reasons for establishing is to have either a living will, a living trust, sorry, or a testamentary trust. Okay, so that will be, which means that the money doesn't go straight, but it's held in trust and it is divided according to some specific rules. Okay, if you have more questions, I won't stop much to the trust. Send me an email if you have more questions about that. But again, it's not very used unless your situation is requiring it. Now, this is a third document. I actually, when I explain it to my clients, I put it, if I say this is actually the most important, and I'll tell you why. If you die without a will, it's not good. But there's still some rules with the government that there's a way how to divide it, and sometimes actually people choose to have no will because they just have one kid, or and they know where it's going, and it's a little bit of headache, it's a little bit of longer procedure, but it's not that big of a deal. What happens though if you are incapacitated, or you have an accident, or you kick your head, or like you're not 100% there, and or you're out of country and you need somebody to sign on your behalf, or you have a dementia or Alzheimer, or a stroke. So if you don't have that, again, I don't want to use uncensored word, but you're screwed, right? So you are really in a bad situation, because the only way out of that, you have to pay to go through a procedure called committeeship. And I asked some friends, lawyers, and they say it's about $15,000. It takes about 10 months to a year. And if it's a contested committeeship, then it goes to hundreds of thousands of dollars. And this 300, I don't know how much is now in my fees for a power of attorney, is just like such a valuable document to have. I would say you have a property, you need a power of attorney. Appoint your spouse first, and maybe a brother, sister, or a mom, dad, daughter, son, whoever you trust, just in case. So by the way, the attorney is not the lawyer. I put that just in case. The attorney is that representative who is agent who will be doing that for you. Okay. You might use it when you're incapacitated, so which is called enduring power of attorney, or could be the time when, as I said, you could be stranded in, like especially now of COVID. Let's say you're stranded in the States, you can't come back, and you're selling your house. You have a power of attorney, your friend, or hopefully not the neighbor, but maybe a family friend, just comes in and signs the documents, and you can sell the house with a family friend or somebody who is your attorney. And the last one, well, it's not the last one, but it's one of the, sorry. Okay. So the last one is for if the power of attorney covers you for financial and legal decisions. This one would cover for care. Oh, let me say actually one more thing. So I don't know your background, each of you. I see that there are about 20 people there. But my advice is to, if you know somebody, I know that most of you maybe are in the medical system. So I know that sometimes there are directives to not advise, give advice or something like that about power of attorney or will, and you don't need to do that. But if you see that the people are losing their mental capacity, they're just, like, humanly speaking, just tell them that they should talk to a lawyer or notary to, you know how when people have cancer, that they say to put their affairs in order. Like, they don't have to wait for that time. If you see that their capacity is not 100% or it's going that way, just mention in passing. I think there's no liability. I don't know any laws that will hold you accountable for just saying, if for some reason maybe it's a good idea to talk to a notary or a lawyer to have a power of attorney, or talk to them to see, to make sure that you're not losing that capacity window. Because if you come to our office and your capacity is not there, you don't understand. There is about 6 elements of a capacity. Sometimes people already passed that. We can't make a power of attorney. So unfortunately, in that case, it goes that route of committeeship that I mentioned before. But this medical, so this is we call it representation agreements, and there are 2 types. There's a section 7, just a basic one. And there is section 9, which is a advanced one that talks even about the pulling the plug, don't pull the plug kind of scenario. It's not the assisted, so the medical assistant in dying thing. So that's already legal and it's happening. This is just saying that if you are in a irreversible coma or permanent vegetative state, then you choose to do this and that. And you have our document has some checklist that you will check what you want. So in case that happens and the family has to deal with that, the document will say what you meant. My advice is just make sure you talk to the family. So this one is, I would say, not as important as the power of attorney, but now all the things that's happening in our world, I see more and more people put value on this document as well. So again, more questions, just shoot me an email and I'll cover this more. And the last one is the beneficiary. So as I said, not only making a will, but also by making those beneficiaries in a RRSP, making in a life insurance. So those things go straight to the beneficiary, not tax it. Well, again, various things are taxable, like RRSP, for example, like there's tax, but RRSP is taxed the estate, right? So again, like I don't want to go into the tax too much. Maybe when we have an accountant, we'll go more into that as well. But as I mentioned before, the will variation says spouse and children can challenge that, but not the beneficiary. So if you have registered plans, that's not challengeable. So that's a good part for that. And on the bottom of the slide, you see the blended families are, that's the most valuable to make that, because then, you want to cover for your family, current family, I mean, for your spouse, but you want to take care of your kids from the previous marriage as well. So it's a little bit of a conflict, or so you have to balance those two. Okay, so it's a little bit of a more delicate approach, as I said here. Okay, so the gifts, there are bequests, the gift of life insurance, the securities, and I know, like when you give a estate gift to a charity or to a friend or to a family, it doesn't have to be cash, it doesn't have to be real estate, it could be anything. Okay, so that's just, I hope you know that. So this is, just another reminder, if you're making an estate gift, and if you make it to a charity, make sure it's a Canadian charity, because if it's registered in the States or another country, we had people that knew that they don't get any tax benefits from that. They still did it, because it's where your heart is, right? So if you want to give to a charity that is not in Canada, that's okay. It's just, if you're doing it for tax purposes, then make sure you have the charitable registration number as well. And knowing that the Langley Memorial Hospital Foundation is such a good local cause, and I'm always advocating for that. Like, think about that. So if you know anybody, in your family who is thinking about leaving something to charity, choose something local like this that will benefit your kids, grandkids, and your family in general. I think that's about it, Lisa. I don't know, I think next slide. Yeah, next slide is just question, comments, thoughts, concerns. Hopefully you have less questions, but it happens. If you have more, that's fine too. As I promised, my goal was to just give you a big picture of what estate planning is and what it entails. And if you have questions, that's okay. That means I made you think and I made you generate more questions. But if you do have more questions, what's now 6:50, so I give you another 7-10 minutes so I can be here. And again, I gave you the email. You can scroll up in the chat, and you can save it for yourself, and you can shoot me an email later. I have no problem doing that as well.
Yeah, thank you, Lilian. We're recording this session as well. So I will make sure we send this out to everybody along with the outline of this presentation.
Oh, perfect.
So there's no questions at this time. Perhaps people may think about it later and reach out to you.
Can I make an appointment? Well, that's good, you know. So I think that worked then, you know. So I made it. We can make appointments. We can have a phone call, or we can have Zoom appointments as well. We can have them in person. I don't know if you can see here. We have a plexiglass. We use masks as well. So we have an office in Langley that we can book appointments from 9 to 5. The phone. Maybe I'll put
Trudy. I know it's Trudy. Trudy, I can send the details to you.
Oh, okay. So I put the phone number if you want. But again, if you find the website, you click on the website, all the information is there. Again, Langley office by Costco is the main office, 9 to 5. If you live in Aldergrove, we accommodate that area just by appointment only. Okay.
That's great. Well, thank you very much, Lilian. Thank you for taking your time this evening to share your expertise with us. And so we'll be in touch with everybody with the presentation. If you have more questions, the conversation can continue.
Yes. Yeah. See you guys.
Okay. Thanks very much. Have a good night, everyone.